The full impact of Brexit on the UK economy is still being debated, but there is growing evidence that it has had a negative effect on living standards. A recent study by the Centre for Economic Performance found that Brexit will indeed reduce UK GDP by an average of 4% over the long term. And this means that the average UK household could be £2,300 worse off each year as a result of Brexit. And there are a number of reasons why Brexit is likely to have a negative impact on living standards. One reason is that it has made it more difficult for UK businesses to trade with their EU counterparts. And this has led to higher costs for businesses, which they have often passed on to consumers in the form of higher prices. And another reason is that Brexit has reduced the value of the pound. And this makes imports more expensive, which also puts upward pressure on prices. And in addition, Brexit has made it more difficult for skilled workers to come to the UK. And this has led to labor shortages in some sectors, which has also pushed up wages. The overall impact of Brexit on living standards is likely to vary from person to person, and people who are more reliant on imports or who work in sectors that have been hit hard by Brexit are likely to be worse off. However, even those who are not directly affected by Brexit are likely to see their living standards eroded over time as the economy adjusts to life outside the EU. Of course, it's important to note that the full impact of Brexit is still unknown because it hasn't happened yet completely. It's possible that the UK economy will eventually adapt to life outside the EU and that living standards will eventually recover somewhat. However, at this stage, it seems very likely that Brexit will have a negative impact on living standards for many people in the UK. And we quickly need to talk about what the Rwanda court ruling really means I talked about recently. The debate here in the EU about the outsourcing of asylum procedures to third countries outside the European Union has been given new fuel by the ruling of the Supreme Court of the United Kingdom. The court overturned the plans of the right-wing Conservative government of Prime Minister Rishi Sunak to bring asylum seekers to Rwanda to hand over the asylum procedures to the African country. The court ruled that such procedures are currently illegal in Rwanda, and to do it in Rwanda. And it referred to international agreements, specifically the Geneva Refugee Convention, the United Nations Convention Against Torture, and the European Convention on Human Rights. The court justified its decision by saying that the human rights standards of these conventions are not guaranteed in Rwanda. But which standards are relevant here? The central norm is that of non-refoulement. I mentioned that in other videos already. That means the ban on refoulement from the Geneva Refugee Convention, which is also anchored in the Anti-Torture Convention and the European Convention on Human Rights. This principle states that states parties are prohibited from taking refugees to territories where they are at risk of torture or inhumane treatment. Based on the United Nations Refugee Agency's reports on the Rwandan asylum system, the court in London saw a violation of these standards. In addition to international treaties, customary international law is another source of international law. Both sources of law are equivalent. Customary international law is formed through the corresponding legal beliefs and practices of states. If one follows the court's assessment, this would mean that this standard would also apply if Great Britain had not ratified the relevant conventions. But that wasn't relevant to the actual verdict. In Great Britain, there is a catalogue of human rights with the Human Rights Act, which incorporated the European Convention on Human Rights into British law. And here in Germany, all courts are bound by law and order as well. And this means that all international conventions ratified by Germany must be applied, for example. And even the simple things are tied to it. And the case law of our Federal Constitutional Court makes it clear that any deviation from the European Convention on Human Rights must be well justified in its interpretation by the European Court of Human Rights. And if a court ignores the case law of the European Court of Human Rights, a person affected by this can lodge a constitutional complaint here with the Federal Constitutional Court. And the court in London simply said that such procedures are not possible in Rwanda. And there was no judgment about what was possible in another country. In principle, here at the EU level and in Germany, there is the possibility of deportations to safe third countries via the so-called third country clause. And this clause implies that such procedures are generally possible in safe third countries. But the outcome is important here as well. And it must be ensured that people in this country are not subjected to inhumane treatment, that the country does not deport them to a persecuting state, and that a fair procedure for an asylum application is guaranteed. And this would also have to be checked on an ongoing basis. A binding agreement would have to be concluded with the respective state. This is usually accompanied by monetary payments. Britain is said to have already paid £140 million to Rwanda for this. The demand for compliance with standards and their review mean significant interference in the internal affairs of the respective partner countries. At the moment, hardly anyone has spoken to the countries in question. The EU Procedural Directive for Asylum Procedure still stipulates that there must be a relationship with the country to which the person is brought. To date, UNHCR has been active in the context of resettlement procedures. It proposes that states that have agreed to cooperate to accept refugees who are in a country of first refuge, and these third countries must be prepared to accept the refugees and then check this for each of the proposed persons. In the European context, such a procedure only works if all states are already willing to accept such refugees, and so far the process has only worked for a relatively small number of refugees. It remains unclear whether it's also suitable for helping with large-scale crises involving millions of refugees displaced by war and climate change. But is there a partner country in which such asylum procedures would be possible in compliance with applicable international law? Let's go through North Africa here. Egypt is a military dictatorship where human rights are not good. In Libya, the state structures have collapsed. In Tunisia, the president has seized all power and refugees have recently been abandoned in the desert. And Algeria is also not necessarily known for its rule of law. So the best opportunity there would still be Morocco. But nevertheless, we will see what Sunak does. He has elections in Britain in the foreseeable future, and that's where our next topic takes us. Because Britain's election watchdog has sounded the alarm and expressed its inability to tackle deepfake content, exposing the UK to the disruptive influence of AI-generated fake videos of politicians in the upcoming election. Britain's election watchdog has issued a dire warning highlighting its lack of authority to deal with the growing threat of deepfake content. This disturbing revelation shows how vulnerable the country is to the possible manipulation of its electoral processes through the use of AI-generated fake videos. Artificial intelligence experts have warned that the next UK election could be influenced by convincing AI-generated deepfake audio and video recordings of political figures here, and this technology poses a significant risk to the integrity of democratic processes. In recent months, there have been notable cases of convincing AI-generated deepfake content targeting political figures, particularly within the Labour Party. In early October, an X account published what appeared to be an audio recording of Labour leader Sir Keir Starmer making derogatory comments about his party staff. And this was followed by a fake audio clip of London Labour Mayor Sadiq Khan appearing to express disrespect for remembrance commemorations. The legal status of deepfake videos and audio involving political figures remains uncertain, although it may fall under the new measures for malicious communications in the Online Security Act. Authorities have faced challenges in tackling such content. Notably, the Metropolitan Police has closed the investigations into the Sadiq Khan deepfake on the grounds that it was not a criminal offense. Experts are raising concerns that AI-generated fake videos of politicians could go viral in the run-up to the next election. The ease and low cost of producing convincing fake videos of public figures saying or doing scandalous things has made such interventions increasingly accessible. Many experts in the field believe that hostile state actors could use new technologies to influence elections in the UK and disrupt the democratic process. From November 23, campaign materials must contain an imprint identifying the publisher of certain online political content. However, there is no obligation to disclose whether the content is AI generated, and the Electoral Commission lacks the power to sanction or remove misinformation. Although Ofcom has more regulatory powers in this area, the legal framework for AI-generated political misinformation and deepfakes remains unclear. The Electoral Commission has clarified its role in combating deepfakes and campaign content, saying it is primarily responsible for regulating party and campaign financing and ensuring compliance with digital imprint requirements. Although the Commission recognizes the challenges posed by AI-generated content, it does not have the jurisdiction to directly combat deepfake-related issues. The Commission is actively working with partners and other regulators to gain a better understanding of the opportunities and challenges presented by AI technology in elections. Additionally, it encourages voters to critically evaluate online information, provides guidance on identifying fake news, and refers concerns to appropriate regulators. And the Electoral Commission recognizes the limitations of the current rules and advocates that the UK government strengthen the authority of UK regulators, including the Commission itself. In particular, the Commission is seeking greater powers to obtain information from social media platforms, technology companies, and online payment providers. The aim of this initiative is to dent the sources of funding for political misinformation campaigns, thereby addressing a critical aspect of the problem. Media reached out several times to tech giants to inquire about their policies and measures to combat harmful political deepfakes. TikTok, for example, said it bans all political advertising and requires clear disclosure of synthetic media or manipulated content that depicts realistic scenes. TikTok also has strict policies against misinformation, they say. And Google Alphabet highlighted its ongoing efforts to combat misinformation and its experiments with watermarking technologies to label AI-generated content. Google has announced SynthID, a tool to embed imperceptible digital watermarks into AI-generated images to verify their authenticity. Google also highlighted its progress in recognizing synthetic speech with nearly 99% accuracy and announced plans to update its political content policy. This update requires verified election advertisers to prominently display synthetic content in their ads, including images, videos, and audio. And YouTube, owned by Google, has a strict policy against technically manipulated content that misleads viewers and risks significant harm. YouTube also requires creators to disclose when they create altered or synthetic content that appears realistic. The main risk associated with AI-generated deepfake content is the creation of convincing videos depicting events that never happened or people saying or doing things they never did. And this risk becomes particularly sensitive in the context of election campaigns, where public opinion can be influenced by such misleading content. Meta Facebook did not respond to inquiries about their policies and measures to combat political deepfakes. And X responded with an automated response and provided no further details about their stance or actions regarding the issue. As the threat of AI-generated deepfakes threatens democratic processes in the UK, the country faces the critical challenges of effectively regulating and combating the spread of this misleading content. The involvement of tech giants in implementing measures to combat deepfakes underscores the urgency of addressing this issue to protect the integrity of elections and the democratic discourse. The EU does a lot on this at the moment as well, by the way. But there also is some talk about Boris Johnson's negotiating tactics during the Brexit negotiations I need to talk about. The European Union has never believed that Boris Johnson was serious about leaving the EU without a deal, according to a number of sources. This is despite Johnson's repeated claims that he was prepared to walk away from the negotiations if he did not get the deal he wanted. EU officials have privately said that they believe Johnson is a showman and his threats of a no-deal Brexit were simply a negotiating tactic. And they point to the fact that Johnson has never actually set out a detailed plan for what would happen if there was no deal, and that he has even admitted that he does not want a no-deal Brexit. In a recent interview, EU chief negotiator Michel Barnier said that he was not convinced that Johnson was serious about a no-deal Brexit. He also said that the EU was prepared for all eventualities at the time, including a no-deal Brexit, but that they hoped to avoid this outcome. And Johnson's own advisors have also cast doubt on his commitment to a no-deal Brexit. In a recent leaked memo, Johnson's former chief advisor Dominic Cummings said that Johnson was only half serious about a no-deal Brexit. Cummings also said that Johnson was not prepared for the consequences of a no-deal Brexit. The EU's assessment of Johnson's intentions is likely to be based on this number of factors, including his public statements, his private conversations with EU officials, and of course his actions as Prime Minister. It is also likely to be influenced by the EU's own assessment of the UK's negotiating position. The EU's belief that Johnson wasn't serious about a no-deal Brexit is significant because it suggests that the EU was not prepared to make major concessions in order to avoid this no-deal Brexit. And this made it more difficult to reach the deal on Brexit, and it increased the risk of a no-deal Brexit even. But it's important to note that the EU's assessment of Johnson's intention was just that, an assessment. It is possible that Johnson was prepared to walk away from the negotiations if he didn't get the deal he wanted, but he didn't get the deal he wanted in the end, to be honest. And so it is most probable that the EU was right here. And if you want to know more about Brexit or some other very interesting topics I found this week, the next video is right here in the end screen. I'll see you there. I'll be back.